Hello, my name is Adam Thierer. I'm a senior fellow with the Progress and Freedom Foundation in Washington, D.C. I'd like to do a presentation for you today entitled America's First Amendment Twilight Zone and What to Do About it. The purpose of this presentation is to illustrate the problems with how lawmakers and the courts currently interpret the First Amendment in this country, and to show how illogical it is to determine First Amendment protections by medium or mode of transmission, and then finally to make the case for a consistent First Amendment for our information age. This presentation is based upon a variety of PFF filings and papers that are all available on the PFF website at pff.org. Okay, let's start with the First Amendment. It's really pretty clear. Congress shall make no law abridging the freedom of speech. Well, even though that's very clear, unfortunately, our modern jurisprudence is not. Congress and the courts have made a real mess of it. Indeed, the First Amendment today, at least as Congress and the courts have read it, is really a house divided. We are stuck in a veritable jurisprudential twilight zone in which identical words and images are being regulated in completely different ways depending on the mode of transmission. To understand how crazy this is, consider this thought experiment from First Amendment expert Robert Corn-Revere of the law firm of Davis Wright Tremaine. Here's a scenario Bob uses in a lot of his work. Imagine, he says, a regulator walking into a room where the same program is being shown on 5 or 6 different screens. So, imagine, for example, a George Carlin monologue playing on 6 screens when you walk into a room. On which of these screens can George speak freely? Which screen gets full First Amendment protection? Well, the current problem today is that a regulator looking at these screens would not be able to determine the regulatory treatment of each until he determined how the signal had been transmitted to each one. In essence, to quote Justice Robert Jackson, each medium is a law unto itself. So, here's some more screens of George, and let's put some technologies or devices behind George's face. Okay, now let's ask, which one receives First Amendment protection and which does not? Well, what if George is on that mobile phone? Safe there. How about that iPod? Safe there too. How about cable, satellite, and DVD? Yep, generally gets First Amendment protection. What about a portable video game system or any video game system? Yep, safe there too. How about the internet and computing? Yep, safe. But what about broadcast television and radio? Well, that's where things get a little bit screwy, and the First Amendment treatment is not equal. Well, welcome to the Twilight Zone. What we do in this country is we regulate broadcasting differently than all other media. Basically, the court has applied a so-called relaxed standard of scrutiny to constitutional challenges on the First Amendment grounds. This has led to things like indecency regulations, political airtime rules, educational mandates, and even the fairness doctrine being applied to broadcast television and radio. On the other end of the spectrum, you have print, internet, and video games, where the scrutiny that the court has taken into account has been strict, and these mediums have been largely free of regulation as a result. Somewhere in the middle, you have cable and satellite, where you have strict scrutiny for most speech issues, but intermediate scrutiny when the matter seems to be more economic in character. So the question is, can such a schizophrenic regime survive in an age of information abundance and platform convergence, and to what extent is technological convergence leading to policy convergence, and if so, in which direction should that convergence occur? Should broadcasting be treated more like the internet and print, or vice versa? And one might ask, why not apply the old paradigm to everything? Well, the problem is the world has changed, and changed radically. You shouldn't really be regulating new media like broadcasting, especially when the old broadcast rationales for regulation are dying, if not dead. Scarcity, for example, is the oldest of the regulatory rationales. It's never really a good reason for secondary First Amendment treatment of anyone, but it certainly is no longer valid in an age of abundance. Likewise, pervasiveness is now moot. Pervasiveness is the notion of broadcasting being uniquely accessible to children or uniquely pervasive in the home. That was never really a good reason to have, again, second-class citizenship rights for broadcasters. And regardless, everything's now pervasive, so it doesn't make sense. And licensing of broadcasting is less and less important as more and more media is unlicensed. The new reality is abundance and convergence. Everything is coming together into one big bucket of bits, if you will. To quote Nicholas Negroponte, bits are bits. Again, everything is coming together. So even though the old reality looks something like this, with each media receiving slightly different First Amendment treatment, in the new world, the new reality is one where everything is ones and zeros and everything is coming together. Again, bits are bits. So something's got to give, but what? Again, the big question is, will technological convergence lead to regulatory convergence? And the danger here is that the internet, video games, mobile media content, social networks, and so on could end up getting regulated like broadcast TV and radio have always been regulated. For example, here are some case studies to show you how this could occur. There was a bill passed last year called the Child Safe Viewing Act and signed by President Bush that requires the Federal Communications Commission to examine the availability of advanced blocking controls that could be used across a wide variety of distribution platforms, including wired, wireless, and internet platforms, essentially to regulate them. The FCC's implementing rule on this basically mentions a whole host of technologies it currently has no jurisdiction over, including things like iPods, TiVos, MP3 players, and so on. Well, welcome to convergence-era content regulation. Another case study is the Indecent and Gratuitous and Excessively Violent Programming Control Act of 2005, which, although it did not pass, was considered by the 109th Congress. It would have expanded broadcast indecency fines and penalties to reach cable and satellite television, and in the process also expand indecency to include excessively violent video programming and censor it accordingly. Again, this is convergence-era content regulation with a vengeance. So, how do we stop this? Well, there are two strategies. One is the principled one that I favor, which is First Amendment equality regardless of media platform. Again, bits are bits and speech is speech, period. The mode of transmission should be irrelevant, and all speech and platforms should get the gold standard of First Amendment protection. The problem here is obvious. It's unlikely that Congress and the FCC are willing to go along with this, and there's lots of people on both the left and the right who will want to preserve and extend the old regime. Therefore, it's likely that our only hope here lies in the courts to go this route. Second option is the more practical approach of firewalling off broadcasting to contain the regulatory damage. In other words, throw the broadcasters under the bus. Preserve the old Twilight Zone in order to keep old and new media separate and keep the internet and new media protected from that regulation. Well, the problem with this is it's blatantly unfair to broadcasters, especially at a time when those broadcasters are fighting for their very survival. Moreover, there's a question of will this firewalling strategy really work? The obvious objection to both approaches, however, is who will protect the children? Aw, look at these kids. Petting a pony. Who's going to protect them from that evil, evil media? Well, folks, these are my kids, and I'd like to think I'm going to protect them and do a good job of parenting for them and watching over them and what they see and consume. And that really gets to the heart of my approach to this, which is based on parental responsibility. More specifically, the answer here is to empower and to educate. And the good news is there's an unprecedented abundance of parental control tools and methods out there on the market today, as I document in my PFF book, Parental Controls and Online Child Protection, a survey of tools and methods. Therefore, government need not play the role of national nanny when parents have been empowered to take these matters into their own hands. Therefore, we need to work together to give parents more and better tools and to educate kids about proper media use. Again, please read my book. It's freely available on the PFF website at pff.org, where you can get a copy. It's about 250 pages and growing all the time. I update it every 3 to 6 months. One closing thought. It's important to understand that in an age of information abundance, neither parental control tools nor government regulation could ever be perfect or bottle up all the objectionable content out there. Therefore, at the end of the day, there is simply no substitute for talking to our children in an open, loving, and understanding fashion about the realities of this world, including the more distasteful bits. In other words, talk to your kids, folks. That's what's the most important approach. I thank you for your time. This concludes my presentation. You can find out more information about this issue at the PFF website at pff.org, and there you'll find a variety of papers and studies on this issue that will tell you a lot more if you're interested. Thanks for listening.